big positive in the state of Kansas is there's a preference for joint or shared parenting uh, in that initial hearing or in the permanent order. So, in your experience, what does the state of Kansas look like for dads, and how does that process go down?
Well, typically, if I have a dad walk in my office, there's one of two situations. So the first is that there's been a petition filed against him for a child, and there's already temporary orders in effect. In that situation, we try to come up with a way to combat the temporary orders, which includes typically filing a motion to modify temporary orders. Most of the time, dads are given as a default every other weekend, maybe one night a week, depending on their interaction with the child. We like to combat that and try to get it back to a shared plan. Now, if dad comes in prior to a petition being filed, then we like to file as soon as possible. I mean, that's kind of the name of the game in Kansas is file first, get the temporary orders in your favor. And, if we like to kind of play it fair and go shared. Now, if it's going to be highly contested, then obviously we have to do what's best for our client. And, there's points where we get it's called residential custody in Kansas, where you get predominantly most of the time, and we might give mom every other weekend. Now they're going to do the same thing as we did in the first situation and file a motion to modify, and then you'll find yourself in court. So that's kind of the first inclination of what we do when somebody walks through the door.
Yeah, I think there are a couple of key points. And I think the first one, I don't know if it's just us as attorneys. I don't know if it necessarily changes the fortunes, but filing first. I always tell clients, hey, it's best if we file first, we set the tone. The first brief the judge reads is ours, and it gets us into court sooner. Where if you wait, they may set the tone. Quite
Yeah.
frankly, in my opinion, with a lot of times we try to put out the olive branch with that initial filing. Like, hey, we're not going to go to war here. We want to work with you. Where she may go out and hire an attorney that immediately wants to go to battle and wants to make it contested. Whereas if you're the first one and they don't have an attorney yet, and we lay something out that's super friendly and it says all over the place, we want to work together
Mm-hmm.
and we're not trying to prolong this, you may be able to get it done quicker. Because in my opinion, and I'll pass it over to you, my opinion for dads, the quicker these things resolve themselves, the better the outcome typically is for dads. The longer these get drawn out, allegations, just different
Mm-hmm.
situations, it makes it messier, it makes it tougher, and I think it puts dads at a disadvantage.
That is the absolute truth. You nailed it. Uh, you know, we go by saying you can't score if you don't have the ball, and if you foul first, you got the ball in your court. Now, typically, what we do, or my practice is that I like to obviously file first, get temporary orders that are heavily in our favor. But then also, if there's an attorney on the other side, or even if I'm working with a pro se litigant on the other side, I reach out to them and say, look, we got the temporary orders, but that doesn't mean the show's over. We want to get this done as quick as possible so that you guys can go back to co-parenting, because in Kansas, co-parenting is one of the major factors in the best interest standard that determines, how the custody proceeding is going to go. So if you can't co-parent, we're going to use that against you. And, in the temporary orders, if I call you and say, we got temporary orders in our favor, but we want to work it out, let's get as close to shared as we can, then the temperament of the other side really dictates how that next conversation goes after that.
I think that's a big thing when you are looking for an attorney and you're looking at the reviews, you're talking to people. I find a lot of people are surprised when I say, "Hey, the minute we file, I'm calling the other side." Or if you have a good enough relationship with them, I'm going to have you take what you filed and say, "Hey, can we go grab some lunch? Hey, can we meet up here? Hey, I filed this. I just want to get something formally through the court,
Yeah.
and we're not going to war." The best situations I've ever had in divorces, the ones where both parents leave the situation with a positive taste in their mouth and they get out of there for, we'll say, less than $10,000 combined. I had the dad literally prior to them getting formally served take the paperwork and say, here's what I filed, not trying to go to war with you. Here's exactly what I want. And then 6 weeks later, we're closing in on having a final judgment, a settlement agreement
Mm-hmm.
in place where if you kind of mess around with it, like I said, I think the longer it goes for dads, the more difficult it gets. There just gets to
Absolutely.
be, and every single hearing you have, you're both going to say something bad about the other person and make co-parenting tougher. Um, and you mentioned it, being a lot of these states lend themselves to being mom friendly, and the domestic violence laws lending themselves to maybe some very light allegations causing issues. It's in your best interest to just get it over with,
Right.
and get something that works for both of you, because nobody wants the judge to be the one that determines what's best for their family.
And
Um,
trust me, the judge, at least in our district, the judge doesn't want to be the one to determine. It is notorious. There's a litany of case law out there that states judges do not like making decisions in custody cases. They are the hardest cases. The judge in Allen County will readily say he was involved in a multi-million-dollar oil and gas deal, huge. Like, they had attorneys flying in from New York, LA, Dallas, all over the place. And he says every custody case, that the custody cases to him are more important than the oil and gas cases, because that is dealing with people's lives. The oil and gas is just money, but dealing
that's
with people's
millionaires and
lives is
billionaires money.
extremely important. So
I had the same thing. I had from Colorado. Heather Mitchell came on, and she was a former criminal defense attorney and formerly worked at the federal and state level as a prosecutor. And she said that family law is absolutely harder because no matter what type of jail sentence the person was facing, the children are just so much more important.
yeah, yeah,
So
but
we mentioned, and we talked a little bit before we went on air. So we talked about the longer these drag out, the more likely you see allegations of domestic violence, different things like that. How does domestic violence or allegations of domestic violence play out in the state of Kansas?
so you know what I was referring to before was most likely a paternity action or a divorce case. Now, there are ways to get around both of those and get temporary orders for custody for your children, and that is through what's called a protection from abuse case. We call these kind of just a knockoff paternity action, in that sometimes women make false allegations against a man, or very loose allegations against a man that are kind of extrapolated out of an incident that sometimes it's just highly exaggerated.
Hmm.
And so they'll file pro se, usually a protection from abuse action. It's filed with a petition, and with that, you get temporary orders of the child. So they'll go to court for this protection from abuse, and um, the judge, per statute, is ordered to make his final order in a protection from abuse with an abundance of caution. So to me, the burden then isn't as high on the woman to get that final order in a protection from abuse case, which also comes with a final order in a custody matter. So
Yep.
she can get custody of the child through a protection from abuse case, and then have custody of the child for, say, 3 months prior to even filing a paternity action or a divorce case. And the PFA order trumps everything. So dad can go in and file the paternity action, but there's already a PFA on file. That temporary order is going to hold. So it might take 3 months to get the PFA case done. Dad's already behind the eight ball because he hasn't seen the kid in 3 months. So him getting custody back to shared is going to be almost impossible. I mean, it happens because then you can go back and fight the case, fight the facts from the PFA, but it is extremely difficult in that situation to get it back to even.
Yeah, I think that when I talk to people about this, that the burden to get that in California we call it a DVRO, domestic violence restraining order, or Kansas a PFA. The burden to get that temporary order granted is extremely low, very low. And in California, then you're 21 to 25 days from being in front of a judge to be able to fight that. They're going to give temporary orders in the interim, and then the burden to grant it. I think the most problematic part is the burden to grant it. In California, it's preponderance of the evidence, but there's no incentive for a judge to not grant it. Not granting it puts the judge at risk. Their name ends up in the paper, their name ends up in the news. Where if they grant it, it's just the dad that has to deal with that now.
You are exactly right. The worst thing, and I would like to think judges don't keep this in their mind, but they're human. They do. in the back of their mind, the judge is probably thinking, if I don't grant this PFA and a subsequent incident occurs, they're going to look directly at me and say, why didn't I grant this PFA when I'm supposed to use an abundance of caution?
Yeah.
And no judge wants that.
Yeah, it's tough, and it can be hard to comprehend because I mean, hey, before you step into it, and I know you and I both came from an athletics heavy background, and the legal stuff that we heard about prior to stepping into family court, it's like, oh, we're going to a courtroom in the United States of America. This is going to be fair. They're going to figure this out. They're going to see through all of this, but it just simply doesn't work that way in family court.
It doesn't because, um, so in that situation with a PFA, or even if there's any kind of allegation of domestic violence, if you breathe that in a courtroom, the judge is automatically going to have a disposition toward that because there's a threat of it, there's the allegation of it. That's going to be in the back of his mind, and honestly, that's one of the factors that judges consider in the best interest standard, which aren't always geared toward a father, especially in the younger ages. Best interest involves who gets the kid to and from school, who gets the child up and ready in the morning, who feeds the child, and on a young child, say that child's breastfeeding, the mother is going to do 99% of that because the child's breastfeeding. So the mother's going to argue, well, maybe the father shouldn't have overnight visits because I have to wake up at 2 a.m. and breastfeed and he can't do that. Well, there are ways around that. That's their default setting, is to argue that. The way
Mm-hmm.
around that is to make arguments like, well, moms freeze milk to go out and have a drink with their friends. Well, most people don't think of that, but that's kind of our spin zone, is that you can freeze milk, you can do other things to take care of your child, and that's how you kind of offset, I guess, the difference in that burden.
Yeah, that's definitely one of the things that you see. It's kind of I have a case right now where it's kind of ironic. The tables are completely turned. It's almost weird. I have a case where like she's been found guilty criminally of domestic violence. He's been the primary caretaker, and with me, I know you represent both men and women. I represent only men, so you get a little bit more view of both sides. But I'm talking on the phone with opposing counsel earlier this week, and we were talking about a visitation schedule because once there's domestic violence involved, it's presumed the party who perpetuated it should not have legal or physical custody. They should just have visitation. And I'm like, okay, so my client's going to be wants to be super reasonable. He doesn't want to. He's not out to get her. We're willing to do this. Like essentially, we were offering her like substantial visitation,
Mhm.
and opposing counsel came back and she's like, well, that's not fair, that's not right. And I'm like, to be candid, the case law says we can't grant 50-50. The courts won't grant 50-50. We would have to agree to that. And she's like, that's a BS argument. And I'm like, yeah, it's one that gets made against me every single week, but it's
Yeah,
what the case law says.
yeah.